And our guest speaker, it turns out, is quite a draw card. That is Tammy McLeod. Now, Tammy leads the trust team at Devonport Law. She is from over on the North Shore, so we're going to give her a big welcome. She's also a partner, or at least a director of Buxton Capital, and she's got extensive involvement in the community. She's been the president of Auckland Women in Law, the North Harbour Chamber or Foundation, and she's also a parent director on the board of Kristen School. So she's somebody who, I know it's a bit hackneyed, but she is someone who gives back, and she's also a leader in her field. So we're very grateful to have Tammy along here today to shed some light on what these legislative changes mean for you and your trust. Thank you very much, Tammy, and welcome.
There's a number of reasons why people have trusts, and as a lawyer I come to it from an asset protection perspective. So about protecting your assets, regardless of who that's from, whether it's creditor protection, there can be relationship property reasons why assets should be ring-fenced, particularly inheritance or assets that you're passing on to children. Tax flexibility does feature there as well. Trusts are the most flexible vehicle that we know, not only for ownership but also for tax purposes. Estate planning, so just traditional good old estate planning where you're looking after your assets for future generations, and there might be reasons why you want to have a trust set up so that the people that you want to benefit from the assets truly will. So whether you're protecting it from spouses or a child that might have their own difficulties or issues, trusts are still a really great vehicle for protecting assets going forward. And of course long-term hold of assets, which is why trusts were set up originally back in the days of the Crusades, when the knight would go off to the Crusades, leave his estate behind in the hands of the neighbour to hold on trust for his family if he didn't come back. And so these days the way we look at long-term hold of assets, it might be a family holiday home, it could be a business which you want to be held for generations to come so that the income's passed out to beneficiaries in the future, but these are all really good reasons to have trusts. So I thought that I'd just start off with that because trusts do get quite a bit of bad press these days, and if you read some of the local journalism, they do get a lot of bad press, and a lot of people say things like trusts aren't worth the paper they're written on, and there's no need to have a trust anymore. But that's absolutely not true. True for some people, but for most people, a lot of people, there's still really good reason to have your trust. So the purpose of the Act is to make trust law more accessible. So trust law has traditionally been a whole lot of cases which have been heard over the years, and so if you wanted to know what the trust law was, you would have to go back and look at 100 years, maybe even 150 years of case law. So the purpose of the Act was to put it all in one place so that any one of us could go and look at the Trusts Act and know what the trust law was, so to make it more accessible and understandable. But one thing I do want to make really clear is that the trust law, I call it evolution, not revolution. So it wasn't a whole out with the old, in with the new. It was more about just making it really clear and clarifying what the trust law was to be. But it does give more responsibility for trustees, greater accountability to beneficiaries, and in my view, it's all about best practice. And I think trust law, you can link it a little bit to employment law. The rights of the employee at the moment seem to be greater than the rights of the employer. Landlord-tenant, the rights of the tenant are becoming more important than the rights of the landlords, and trusts are a bit the same. So the rights of the beneficiaries are definitely coming to the fore. What do you need to know? And these are the things I'm going to go over today. So the first is trustee duties. The second is the rights of beneficiaries, which I think in my view is the most interesting part of the new Trust Act. Thirdly, information retention and giving. Fourth, incapacity of trustees. There's some good new legislation around that. And 5, the life of a trust. So under the Trust Act now there's mandatory duties and default duties, and I won't go into these too much, but just to give you an idea, the mandatory duties of trustees are things that trustees cannot contract out of. So you can't say something different in the trust deed. So these are the things that trustees always must comply with, and they are to understand the terms of the trust deed, always to act in the best interest of the beneficiaries, and in my view that's the most important role of the trustee, to act honestly and in good faith, which seems a bit like a given really, to exercise the trustee's powers for proper purpose, account to the beneficiaries. That doesn't mean provide accounts to the beneficiaries, but more be responsible to the beneficiaries. And being a trustee is a personal liability, which is quite confronting, I guess, for some people. So if you're a trustee of a friend's trust, it is a personal liability. And often when you're contracting with third parties, you try and contract out of that personal liability, but otherwise it is personal. So if I'm a trustee on your trust and you haven't paid your rates, the council can come to me and I have to pay those. And I might be able to get the money back from the trust, but it's still my personal liability to pay those. So that's quite important. The default duties of trustees. Now these are the ones that you can contract out of in your trust deed. So you need to make sure your trust deed gives a contrary intention to these matters if you don't want them to apply to your trust. And the first one is impartiality. So that's not thinking about the particular circumstances of, well, you have to think of a beneficiary's circumstances, but not, I don't like your husband and so I'm not going to give you as much as your sister because she's in this great relationship. So impartiality is a default duty. Unanimity, so that's all trustees have to agree before they decide to do something. You can contract out of that. I'd be a bit wary about contracting out of that, because as a trustee, if you can be outvoted by your other trustees, you can still be bound by their decision if you don't have unanimity. And just thinking back to that personal liability, you don't really want to be in a position where you're personally liable for a decision that you don't agree with. Not to profit from the trust, and often you'll see that can be contracted out of because you could have a conflict situation where you've got people whose assets are actually in the trust and so they want to profit from the trust in one way or another, so that's something to look at. The duty to invest prudently, this is quite an important one, and if you do have a trust yourself, then I highly recommend that you look at your trustee to see whether this default duty has been contracted out of or not, because without contracting out of the duty to invest prudently, trustees are held at a very, very high standard, to the point where if you don't diversify the assets of the trust, you could be sued in the future. And there was a case a number of years ago where the trust was set up for a widow to receive income during her lifetime, and it was in the 1980s, back in the days of very high interest, and so the trustees were quite pleased with themselves. They'd invested this money in term deposits, paid the widow an income for her lifetime, which was fantastic, but when she passed away, the beneficiaries sued the trustees because they hadn't diversified the assets, and while they'd kept the capital base, they hadn't grown the value with inflation. So very, very important, because most New Zealand trusts hold a family home, perhaps a closely held business, perhaps a batch, so not particularly diversified. So that's something that I think is very important to look at. The trustees need to retain the core documents, and the core documents, so every trustee needs to hold these, so that's the trust deed, any resolutions, any other documentation, variations to the trust deed, etc. So all trustees need to hold those documents. And also trustees need to act for no reward, so it is something that you do just out of the goodness of your heart. If you're a professional trustee, then that's something that we always like to contract out of, because we do love our clients, but we do like to get paid for our services as well. So all of these things are things that you need to look at within the trust deed. But if I was a trustee of a trust that didn't have a contract out of the Act for no reward, I wouldn't be able to be paid for my professional services. So there's a presumption under the new Act that a beneficiary over the age of 18 has the right to know that they are a beneficiary. And so, in my view, and the view of some other people who specialise in this area as well, this doesn't mean that you need to write to all your beneficiaries over the age of 18 and tell them that they're a beneficiary of the trust. It's a presumption. And so if you're not sure, I would take legal advice on that. But once they know that they're a beneficiary, you can tell them who the trustees of the trust are, how to contact them. If there's any changes to the trustees, that's important. And a copy of the trust deed. They're also entitled to see a copy of the trust deed. They also need to know who to go to if they want to receive further information about the trust. So once again, this is a presumption. I have seen some letters where lawyers have written to beneficiaries and said, you're a beneficiary of this trust, here's a copy of the trust deed, these are the trustees, and that's opening up lots and lots of cans of worms. So just be a little bit careful around that. The information that a beneficiary can then ask for once they know that they're a trustee is, as I've already said, a copy of the trust deed and any amendments. They can ask to see the assets and liabilities, so that would normally be a copy of the accounts for the trust, income and expenditure of the trust, and any information regarding the administration of the trust. Now, I say to all my clients, I have a breadth of clients. I have some clients who say, kids know that they're beneficiaries, they know everything that we've got, we don't care if they ask these questions or they won't ask these questions, down to heck no, don't want the kids to know anything that we've got, it's all to be secret squirrels, and how do we deal with that? The ones in the middle are usually, don't mind if the kids know who the beneficiaries are, but don't want their partners to find out, don't mind if the kids know what's in the trust, but don't want their partners to find out what's in the trust through the children. So there's different ways that we can address this. So the trustees do need to consider when they're asked for this information, what are the wishes of the settlors? So is there some indication from the settlors as to what information that we're to give the beneficiaries if they ask? And that's where your memorandum of guidance or letter of wishes, which is, I call it, it's like a will for a trust. So that tells the trustees what you want to happen with the trust assets if something happens to you. And so an indication in that document that yes, we want the children to benefit, or whoever it might be. We do want the children to benefit from the trust, but we don't want them to rely on the trust fund. And so for that reason, we'd want you to be careful about providing information to them. So that's something that you can do. The trustees need to think of the effect of giving the information to the beneficiaries. So if you had a lot of assets in your trust and you had a beneficiary who you think might not be as driven to have their own career and other things and rely on the trust, then you as trustees might consider actually it's not appropriate for that beneficiary to receive that information because we think that it could actually be detrimental to them for whatever reason. You need to think about the practicality of giving the information, and that might be that you might have a beneficiary who was really only meant to benefit from the trust in the event that you've passed away, your children have died, you've got no grandchildren. So they could be a default beneficiary, even though the trust deed might not say that. So that's something else to consider. And also any other relevant considerations, which might be the trust deed itself. So having a look at the trust deed and seeing if there's any indication within the trust deed about what kind of information and how much information can be given is really important. Okay, so the next change in the Trust Act is retention of information by trustees, and a lot of us are familiar with the IRD rules around retaining financial information for 7 years, but under the new Trusts Act, trustees have to keep the information forever. And so that's in case there's ever a question as to what the trustees have been doing in the past by beneficiaries, you need to go back and have a look. And so when this new act came out, I had one set of clients actually who had their trusts were years and years old and they were about to go into a retirement village, and I went to their house, they had boxes of trust documents. And they said, can we get rid of these? And I said, actually, no, you can't anymore. And so what we did was we scanned them all onto little memory sticks, so they still had all their documents there. But only one of the trustees has to hold all that information. So that's a key decision for trustees, is to work out who's going to be holding that information. I think that one thing that with the new Act that becomes really important is trustee meetings. So if you recall, for those of you that do have trusts and have had them for a while, back in the day when we had gift duty, and each year you would gift $27,000 worth of assets to the trust. And so that was a really good touch point for trustees to all get in touch with each other and see what was going on, or just sign the documents depending on how your trust has been run. But these days I think it's best practice to have at least one annual trustee meeting a year, and that's where you can sit down as trustees, talk about things like the insurance on the property. Building costs have increased significantly. Has your insurance kept pace? Are your wishes there? Have any of the children asked for anything from the trust, any information? What are the children's current needs? What are the other beneficiaries' needs? These are all things that should be documented. And I often say that a company, in my view, is like a square box. So you have this square box, you need to tick the boxes, and then you've done your job with your company administration, whereas a trust is more like a cloud. So it's a little bit ethereal in a way. And so it's up to you to make sure that you have the meetings, record the minutes, and that's your evidence that you've got a trust in the event that you need to use it to protect from an outside creditor or whoever it might be. So best practice is completely important with trusts under this new legislation. Under the previous law, if a trustee became incapacitated, then there was often nothing that the other trustees could do apart from go to court to have that trustee removed and to ask the court to transfer the assets into the names of the other trustees. Under this new legislation, it's compulsory to remove an incapacitated trustee. So if you do have a trustee who's lost capacity, then they have to come off as a trustee. We don't need to go to court to get vesting orders anymore, so that other trustees can actually sign a document on behalf of the trust and transfer assets. So it's become a much more economic, practical way of dealing with an incapacitated trustee. It doesn't address, though, who then has the power to appoint trustees. So if you have a settlor or someone who's settled the trust, who then has the power to appoint and remove trustees, and they become incapacitated, unless your trustee deals with that, there might not be a mechanism for other trustees to be appointed in place of the incapacitated trustee. Enduring powers of attorney, which I'm going to talk about at the end, are not relevant to trusts unless your trustee says. So if you lose capacity, it's not whoever your power of attorney is for property. They don't step into your shoes as a trustee. They're quite distinct, two quite distinct things. The other thing that I've seen some lawyers doing is actually putting in place a test for what mental capacity looks like and putting that into the trust deeds now, so that if you tick these boxes, then you're deemed to be mentally incapable, and so you come off as a trustee. One trust deed I saw, one of the things for deeming someone to be mentally incapacitated was that if they wouldn't sign a trust document, which to me seemed a little bit over the top. So just watch if you've got those sorts of provisions within your trust deed, that they are relevant and are workable for your trust and your family circumstances. Okay, so the life of a trust has changed as well. So under the Perpetuities Act 1964, Parliament had said that a trust could last for a maximum of 80 years if you specified that in the trust deed. Unless you've got a trustee which was established pre-2021, then your perpetuity period will probably still apply. But post-2021, post-January 2021, the trust period, it's called now, is 125 years. And that's obviously to take into account longer life expectancies, etc. But after 125 years, the trust has to vest, so it has to go up to beneficiaries at that time. If you had a trust that's got the 80-year perpetuity period and you wanted to extend it, you might be able to vary the trust deed, perhaps. So you need to look at your trust deed then. There is a lot to think about. But I think the key is breathe, don't panic. Don't believe everything that you read about trusts being thrown sort of out with the baby out with the bathwater. There are things that you can do. So if you're thinking there, help, my trust does need updating, what can I do? I think the key thing is to review the purpose of the trust, because it might be that you don't even need it anymore. It could be that the reason that you had it just isn't there. And I'm finding that a lot of clients are wanting to simplify, so they may have had a business, their business is long gone, their children are in really great spaces, they're very settled. They just need a really good will. And so it's really important to know and remember that trusts aren't the panacea to all ills either. So that's a really good starting point. And to be honest, we've been winding up quite a few trusts, particularly people whose, as life moves on, then I often say trusts are a little bit like life insurance. So when the kids are small and your debt's big, you need more life insurance. As the kids grow and your debt shrinks, you need less of it or not at all. And trusts are like that too. So there might be times in your life where you might have even 2, maybe even 3 trusts, depending on the complexity of your circumstances. But as time goes on, sometimes it's time to simplify and just get back to that basic estate planning of just having a will. Review the terms of the trust. So I talked at the beginning around the default duties that apply, who the beneficiaries are, whether you can vary, etc. So you need to have a look and make sure that the terms of your trust still apply to your circumstances. Review who the trustees are. So in my view, I've always been quite staunch on this, but having a professional trustee really does help with that distancing from yourself. It can help particularly if you've got tricky family circumstances. Often I say I'm a good person to blame if something's, if you don't want to do something, you can blame the independent trustee and just say, look, we just simply can't do that. The language of having an independent trustee does remove you from the situation as well. So independent trustees are important. A lot of people are stepping back now, also not wanting to be trustees, so that's something else which might prompt some of these changes for you. Review who the beneficiaries are. So when I first started practicing in the late 1990s, we used to put everyone into the trust deeds. So it would be everyone on the basis that trusts are discretionary and you don't have to benefit the discretionary beneficiaries. That changed a bit when the Property Relationships Act came in 2002. And so then we were trying to narrow down the class of beneficiaries because you didn't want your daughter's husband saying, well, I'm a potential beneficiary of that trust and I'm entitled to be considered, and that's worth something, particularly if they're separated. So that's one really good reason to narrow down. The other good reason, obviously, is with beneficiaries being entitled to ask for more information, you want to make sure that it's only the people that you truly want to benefit who can be asking for that information. If you have reviewed and you have got beneficiaries that you don't necessarily want in there, or there's provisions of the trustee that don't fit with your circumstances or don't fit with some of the new premises under the new Act, what can you do? So the first thing is to look for a power to vary, whether there's a power to vary the trust deed, and if there's a nice broad power in there, which there will be if it's a modern trust, well, there's likely to be if there's a modern trust deed. Varying the trust deed is very, very easy and quite cost effective to do. You can resettle, so that's moving your assets from one trust to another. Just a word of warning, there's tax implications when you resettle. The IRD sees moving assets from one trust to another as if it's a sale, so things like bright line test, GST, depreciation, clawback, all of those things do apply. Also, if you've got company shares, loss of imputation credits, that's another thing that will apply if you do move assets from one trust to another. So that's where it's important that your lawyer and your accountant form a team around you and are working together on that. Power to remove beneficiaries, which is your question there. So if you've got the power to remove beneficiaries, you can narrow that down. I have had some people who do resettle simply on the basis that their trust has got a wide class of beneficiaries and there's no power to remove, no power to vary, and so we actually do resettle. So all of these things are possibilities. Or do I just start again? Do I transfer the assets back to me and then put them into a brand spanking new trust because there's no gift duty anymore? There is some rollover relief in some circumstances with bright line test. So these are the sorts of things that you can be thinking about if your trust isn't fit for purpose anymore. So enduring powers of attorney are part of the asset plan. So will, if you've got a trust, that's great, but will, enduring powers of attorney, in my view, enduring powers of attorney are actually much more important than a will. Because if you die and you don't have a will, then there's a process that we follow under the Administration Act which distributes your assets out. It might not be the way you want it to be, but at least we can follow the process. If you lose capacity and you haven't put in place enduring powers of attorney, we have to go to court. So even if you're in a couple, husband and wife, if I lost capacity, it doesn't follow that my husband can sign things on my behalf. So while he might be able to list our house for sale, he won't be able to sign an agreement for sale and purchase to sell it. So supremely important. There's two kinds. One relates to property, which is pretty clear. Bank accounts, paying your bills, selling your house if it's not in a trust, dealing with investment advisors, etc. The second relates to personal care and welfare. So personal care and welfare decisions around hospitalisation, rest home care, surgery, medication, life support, those sorts of things. With property, you can appoint more than one person, and you can also say that that person or persons has to consult with other members of the family. My advice is not to have too many people, because sometimes then the left hand doesn't know what the right hand's doing, and you need to make sure that everything's cohesive. But it is good to have a backup person. So if I lost capacity and my husband died, have I got a backup person to be able to slot into that role? Personal care and welfare, you can only have one person at a time, and my kind of reason for that, I think, is because doctors don't want to deal with committees. They just want to be dealing with one person. But you can have backups again, and you can have that consultation process as well. If you don't have them, delays, costs and drama, and that's no joke. It can be really stressful for the family if you don't have powers of attorney in place. And I've got one really good example, it's a bad example of a situation which went wrong, where the client lost capacity. He had a stroke. He had children from a previous marriage. He had a new wife with a young baby and a business and a life insurance policy, which would have kicked in. It was actually a trauma policy, I think, which kicked in if he lost capacity, which he did due to his stroke. But he didn't have in place powers of attorney, and the insurance company needed his signature because he owned the policy, but he wasn't able to sign. And so they had to make an application to the court in order for someone to be appointed as his attorney. His new younger wife was applying. She had to be represented. His elderly parents, who also had standing, had to be represented. His children, his adult children from previous relationship, had to be represented. So it's not just the cost, it's the delays. And the court at the moment is doing its best to get through these sorts of things, but there's big delays. And so in that particular situation, that business not having the money when it needed it made a huge difference. So I really encourage everyone, regardless of age and stage, to put in place enduring powers of attorney. So if you've got a trust and you're doing your tax return for the 2022 year, there's a whole lot more information that needs to be provided to the IRD that your accountant will be working through. And what it relates to is who's settled assets into the trust, at what stages and at what value. And previously, if you made an income distribution to a beneficiary, then that would need to be recorded in the tax return. Now, if you make a capital distribution to a beneficiary in the tax year, that has to be recorded in the tax return as well, together with the beneficiary's IRD number. So I'm sure there'll be some other questions around that, but that's generally, so the 2022 year I think will be the biggest one, because that's when this kind of historical information that they're looking at as well. After that, hopefully it just becomes part of what your accountant does when he or she files the tax return for the trust. But this year could take a little bit longer, and you'll be providing more information than you have done in the past, and also probably than what you will need to do in the future.